We now move to the final issue that we considered, and that is the issue of a fair trial. The gist of this issue turns on whether His Excellency Gachagua was subjected to a lawful and fair trial process within the meaning of Articles 47 and 50 of the Constitution. The petitioners contended that the Senate's conduct of the impeachment trial was fundamentally and irreparably flawed, falling far short of the constitutional standards of fairness, legality, and procedural propriety granted to His Excellency Gachagua under the stated provisions. Their challenge on this ground was advanced on several distinct and cumulative bases. They argued that His Excellency Gachagua was denied his right to a fair trial when, having fallen ill and being hospitalized on the 17th of October 2024, the Senate refused adjournment request and proceeded in his absence, ultimately voting on 5 of the impeachment charges. That the Senate was constitutionally bound under Article 145(3)(b) and 145(4)(6) to appoint a special committee of 11 members to investigate the charges. By defeating the motion to establish such a committee and proceeding by plenary, the Senate deprived him of his right under Article 145(5) to appear and be represented before an independent investigative body. Insulated from political pressure, and that the time afforded to H.E. Gachagua was grossly inadequate, only a few days to respond to 11 complex allegations and just 2 hours to present his defense compared to the extensive time given to the National Assembly. The respondents in defense maintained that the Senate had accorded His Excellency Gachagua a lawful and fair trial consistent with Articles 47 and 50 of the Constitution, that the Senate acted reasonably by granting a short adjournment and offering a further extension to 19th October 2024, and when the formal motion was defeated, they submitted that discretion had been properly exercised, especially since no medical evidence was produced. They maintained that the Constitution conferred discretion to proceed by way of a special committee or plenary under Article 145(3)(b), and denied that new evidence or witnesses were introduced at the Senate stage as alleged by H.E. Gachagua. We have carefully considered the forcefully and ably argued positions advanced by both sides. The constitutional standard which the fairness of the Senate conduct falls to be measured is clearly and comprehensively set out in Article 50 of the Constitution. Of particular relevance to the present inquiry are the following guarantees which Article 50 confers on every accused person as components of the right to a fair trial. Under 50C is the right to have adequate time and facilities to prepare a defense. F, to be present when being tried, unless the conduct of the accused person makes it impossible for the trial to proceed. And K, to adduce and challenge evidence. These guarantees do not stand alone. They are reinforced and complemented in the specific context of impeachment proceedings by the procedural rights expressly conferred by Article 145(5) and 145(6)(b) of the Constitution, which provide as follows. 5. The President shall have the right to appear and be represented before the special committee during its investigations. And in 6B, that Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. To the foregoing must be added Article 47 of the Constitution, which guarantees every person the right to fair administrative action that is lawful, reasonable, and procedurally fair. That right is not confined to purely judicial proceedings. It attaches to any exercise of public power that affects a person's rights, interests, or legitimate expectations, and it applies with full force to the impeachment process before a decision to remove is taken. The Supreme Court in Sonko reaffirmed this position, holding that during the process of removal, both the right to fair administrative action under Article 47 and the right to a fair hearing under Article 50 accrue to the office holder whose removal is sought. This court reads that holding as applying with equal force to His Excellency Gachagua in the present proceedings. The Supreme Court further held that while impeachment is a political process, it is equally subject to constitutional discipline and the principles of natural justice, and that courts will not interfere with the merits of Parliament's decision unless a violation of fair hearing rights or procedural improprieties established. These two propositions together define both the standard the Senate was required to meet and the scope of this court's supervisory jurisdiction in assessing whether it did so. Against that framework, we turn to the specific circumstances of the present case. It is clear that during the proceedings, the National Assembly, as the prosecuting party in the Senate proceedings, presented its case through witnesses who were examined in chief and subjected to cross-examination in the full and formal sense of adversarial proceedings. There is no controversy about this fact. The petitioners contend that the Senate's refusal of the adjournment application denied His Excellency Gachagua equality of arms and equal protection of the law by preventing him from participating in the oral proceedings at the precise stage when his own evidence was to be led. The constitutional right to equality of arms has been expressly affirmed by the Court of Appeal in Olo versus Kisumu County Assembly Service Board and another, when the court cited with approval the following passage from Pinnacle Project Limited versus Presbyterian Church of East Africa, Gong Parish, and another. I quote, "Fair trial in civil cases includes the right of access to a court, the right to be heard by a competent, independent, and impartial tribunal, the right to equality of arms, the right to adduce and challenge evidence, the right to legal representation, the right to be informed of the claim in advance before the suit is led, the right to a public hearing, and the right to be heard within a reasonable time." The question in the present case is not whether H.E. Gachagua was given any opportunity to be heard. From the evidence before us, he was. The precise and constitutionally significant question is whether, having been partially heard, the remainder of his participation was unlawfully curtailed at the point when the opposing party had already completed a full adversarial presentation. The National Assembly had presented its case in its entirety, its witnesses had testified, been examined, and cross-examined. His Excellency Gachagua had not completed his. It was at that precise point of procedural imbalance, with the scales of participation tilted irrevocably in favor of one party, that the Senate refused the adjournment and proceeded to vote. That is not a case of a party who was heard and then outvoted. It is a case of a party who was prevented from completing his hearing after his opponent had completed his. What we heard the petitioners to be saying is that His Excellency Gachagua critically was not merely a respondent who had filed documentary evidence. He was, on the uncontroverted evidence before this court, his own sole witness. He was the only person who could speak to the facts from his own personal knowledge, give a first-hand account of the allegations before him, and submit himself to cross-examination in a manner that would have allowed the Senate to assess his credibility directly. The respondents relied on the Court of Appeals decision in Kenya Revenue Authority versus Murgani, a 2010 decision, for the proposition that fairness does not always require an oral hearing, and that provided a body achieves the degree of fairness appropriate to its task, the manner in which it proceeds was a matter for its own institutional judgment. Drawing on local government vote versus Aldrich, as well as the case of Selvarajan versus Res Relations Board and R versus Immigration Appeal Tribunal, the Court of Appeal in the Murgani case concluded that a hearing conducted by way of written exchange may, in appropriate circumstances, constitute a fair hearing. We do accept that general principle as binding on us. However, Murgani is plainly distinguishable on the facts and context that are both material and decisive. That case concerned an administrative determination in which no oral proceedings had been conducted at all. Both parties were in a position of formal procedural equality. The written process was the established mechanism, and the question was simply whether the absence of an oral hearing was fatal to fairness. The present case is fundamentally different. The Senate did not choose at the outset to proceed by way of written submissions alone. It had agreed to a fully adversarial oral hearing with witnesses, examination in chief, and cross-examination. Having adopted that mode of proceeding, the Senate could not, at the moment His Excellency Gachagua was to take the stand as his own sole witness, abandon the adversarial framework it had established for itself without satisfactory reason. To do so was to apply different procedural standards to the two parties. That disparity is the antithesis of equality of arms and is irreconcilable with the constitutional guarantees of Article 47 and Article 50. The Hansard record of the Senate proceedings of 17 October 2024 confirms that following the confirmation by Paul Mwita Senior Counsel to the House that His Excellency Gachagua had been taken ill, several senators who rose to comment explicitly acknowledged on the floor of the Senate that H.E. Gachagua was unwell. Not one of these senators disputed the illness. They acknowledged it, and then proceeded, notwithstanding that acknowledgement, to oppose the adjournment application. The circumstances must also be taken within the directions issued by the Speaker of Senate at the time. The Honorable Speaker stated in part as follows, I quote, "As this process is time-bound by the Constitution, to be concluded in not more than 10 days pursuant to Article 145 as read together with Article 150 of the Constitution, and noting that the period provided for ends on Saturday the 19th of October 2024, the only window open to the Senate, if it is so obliged, the request for adjournment sought by counsel for the Deputy President would be to gazette Saturday the 19th of October 2024 as a further and final day for hearing of this matter. Honorable Senators, ladies and gentlemen, such a request is not made to the Speaker but to the Senate and is accordingly a matter for the Senate to determine. To facilitate this decision, I direct the clerk of the Senate to circulate a supplementary order paper incorporating a notice of motion and a motion for adjournment sought. This being a procedural matter, the motion, if carried, will result in the Speaker gazetting Saturday, the 19th of October 2024, as a sitting day to conclude the hearing and determination of this matter. This being the last day allowed by the Constitution of Kenya for these proceedings to conclude. I close the quote. The Speaker's communication meant that it was in fact open to Senate to adjourn the sitting up to Saturday. The significance of that course of conduct cannot be overstated. The Senate, despite having the option to adjourn and having expressly acknowledged the incapacity of the party before it, nonetheless proceeded to determine his fate in his absence. That was not a proper exercise of constitutional discretion. It was a negation. We are convinced that had the Senate exercised its discretion genuinely, open-mindedly, and with a conscientious regard for the constitutional rights of His Excellency Gachagua, and had it directed its mind to the miscarriage of justice that its refusal was plainly going to occasion, this was a case in which the circumstances unambiguously called for an adjournment to be granted at least to the next day. That conclusion is firmly supported by the Court of Appeal's pronouncement in Kariuki versus Attorney General, a 2014 decision, where the court held as follows, again I quote, while bearing in mind that whether to grant an adjournment or not is discretionary, and appellate courts are loath to readily question the exercise of discretion by the trial court, nevertheless, it must never be forgotten that the right to an adjournment to enable a party to adequately prepare his or her case in a criminal trial is underpinned by no less an instrument than the Constitution. The authorities cited above relate to exercise of discretion to grant or refuse an adjournment in a civil dispute. We are of the opinion that although the same principles are relevant in respect of applications for adjournments of criminal trials, nevertheless, because of the constitutional basis of that right and the potential impact on a citizen's liberty, the court is obliged to be more circumspect in rejecting an application for adjournment and to specifically consider whether denial of such a right guaranteed by the Constitution would result in miscarriage of justice. In denying the appellant's application for adjournment, the court-martial in that particular case also did not address its mind to the critical question of whether denial of the adjournment would occasion a miscarriage of justice. In Job Obanda versus Stage Court International Services Limited and another, this court, that is the Court of Appeal, was emphatic that where, amongst others, a judge fails to apply his mind to the question whether a miscarriage of justice might be occasioned to a party who is refused an adjournment, that would constitute sufficient basis upon which an appellate court would be entitled to interfere with the exercise of jurisdiction, close of quote. We say so with a full appreciation of the non-derogable nature of the right to a fair trial. It is not a right that yields to constitutional timelines or political exigencies. It is an absolute constitutional guarantee, and its violation cannot be justified by reference to any competing constitutional interest, however weighty or pressing that interest may be. This finding becomes even more compelling when one considers the Senate's misdirection in its interpretation of Article 145(4)(b). Senate appeared to imagine that it had 10 days within which to dispense the impeachment hearing itself. Yet, the text and structure of that provision according to us, make it clear that the 10-day period was intended to apply exclusively to the special committee once constituted. We have addressed in detail our understanding of Articles 145(3)b and 145, sub-article 4 to 6 in the preceding section of this judgment, and we do not propose to repeat that analysis again here. Finally, we wish to make brief observations on the affidavit of Dr. Daniel Kibuka Gikonyo, sworn on the 28th of April 2026, which was admitted into evidence by leave of this court and tested by cross-examination when Dr. Gikonyo attended to give oral testimony. There is no doubt that the affidavit was not before the Senate on the 17th of October 2024 when the request for adjournment was made. And on that ground, we do agree with Senate's submission that it could not have informed the House's determination at the time. The affidavit was additionally filed almost 2 years after the petitions were instituted, and no explanation was offered to us, including by Dr. Gikonyo himself, for that delay. For those reasons, we do not attribute significant probative value to it. The circumstances, as we have analyzed, were independently and collectively sufficient to warrant a reasonable adjournment. Dr. Gikonyo's evidence neither adds nor detracts from that conclusion.
In conclusion, therefore, upon careful consideration of the consolidated petitions, the responses filed, the submissions of counsel, and following our deliberations and analysis, we now pronounce ourselves on the issues presented. On jurisdiction, we hold that the impeachment proceedings challenged herein are justiciable. This court possesses jurisdiction under Articles 22, 23, and 165 of the Constitution to determine whether the National Assembly and the Senate acted within constitutional bounds, complied with constitutional procedures, respected constitutional rights, and remained faithful to the constitutional safeguards governing the impeachment of a deputy president. On allegations of bias, the allegations of bias, predetermination, and conflict of interest advanced against the speakers, members of parliament, and senators are unsubstantiated. They rest on political inference and suspicion rather than objective evidence capable of satisfying the required threshold. On public participation, we are satisfied that the public participation conducted by the National Assembly in connection with the impeachment of His Excellency Gachagua met the constitutional threshold. The Senate did not violate Articles 10 or 118 by failure to conduct its own independent public participation. We further hold that public participation was not constitutionally required for the nomination and approval of His Excellency Kindiki as Deputy President under Article 149, Sub-Article 1. Constitutionality and legality of standing orders. We find and hold that the impugned standing orders of the Senate and the National Assembly are not unconstitutional. Composition of the National Assembly, role of IEBC, and nomination of the Deputy President. We find that while the failure by Parliament to enact legislation on the gender rule remains a constitutional concern, this court has recently clarified in the Conchella and others decision that the remedy under Article 261 is still available and must be pursued through the proper procedural channels. Consequently, it would be premature to hold that the National Assembly was improperly constituted for purposes of considering the impeachment motion. We find that no input or intervention by the IEBC was constitutionally required in the midterm replacement process under Article 149, Sub-Article 1. The absence of IEBC involvement did therefore not render the nomination or filling of the vacancy unconstitutional. The gazettement of the Senate resolution, the President's nomination of His Excellency Kindiki, and the National Assembly's approval did not contravene the Constitution merely because they were undertaken expeditiously. We therefore affirm that the nomination and appointment of His Excellency Kindiki as Deputy President was valid. Constitutional processes. We find that Parliament ought to urgently enact a dedicated statutory framework for the removal of the Deputy President under Article 150. The phrase, in quote, with the necessary modifications, is a substantive constitutional directive requiring Parliament to adapt the presidential removal framework to the distinct constitutional position of the Deputy President. However, the absence of such legislation does not vitiate the impeachment process already undertaken. We further hold that under Article 145, the Senate was at liberty to conduct the trial either by way of plenary or through special committee. The right to fair trial under Article 47 and Article 50, we find that His Excellency Gachagua's rights were infringed when the Senate declined to allow an adjournment. This violation constitutes both a vindication of his rights and a recognition of the constitutional infirmity in the process, but does not undo the impeachment itself, given the finality of Article 145, sub-Article 7, and the constitutional absurdity that would arise from dual incumbency. The Constitution is the grundnorm, and where that grundnorm deliberately and unequivocally withholds authority from the court, such limitation must be respected.
I will deal with the aspect of remedies.